I would like to welcome all of you here this morning, and if you'll please stand, Commissioner Morgan will lead us in a prayer, followed by the pledge.
Let us pray. Heavenly Lord, during this time of Advent, let us all remember to take time to make room for the greatest gift that has ever been given to us in the birth of our Savior. May we also attempt to do your will in our work as we conduct our business here today. Make us ever mindful of those in needs and responsive to those needs. Through the help of your Son, our Savior, Jesus Christ. Amen.
Amen.
I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
At this time, I'd like to call the meeting of the Cabell County Commission to order, and we'll start with the first item, which is approval of the regular commission agenda.
Move to approve. Second.
Motion's been made, it's been seconded. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Aye opposed, no. Motion carries. Next item is approval of the minutes for the regular commission meeting, October 10, 2019, October 24th, 2019, November 14th, 2019.
Move to approve.
second.
The motion's been made to approve. It has been seconded. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Opposed, no. Motion carries. Next item is approval of the erroneous assessments, land consolidation, split tickets, probate documentation, county clerk's probate office.
So move.
Motion's been made.
Second.
It's been seconded. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Opposed, no. Motion carries. Next item is approval of purchase orders number 20-95249 through 20-95520, pay jackets, monthly payments to Fifth Third for fuel card purchases, ACH drafts for weekly claims experience, administration cost Highmark.
So move.
Second.
Motion's been made. It's been seconded. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Opposed, no. Motion carries. The next item on our agenda is citizens registered to speak, and we have some folks who have signed in to speak, but if you would like to speak and you didn't get to sign in, we will give you an opportunity to do that. We'll start with Floyd Conley, who's with the United Mine Workers Association.
I'm here today to represent the Cabell County EMS workers, and we're demanding to have a vote and go with the outcome of the vote.
I think you have requested that before, haven't you?
Not a vote.
Not a vote, okay. Well, that's something we'll have to consider because it's not on our agenda for today.
Okay.
Thank you. Jacob Levi Smith from United Mine Workers.
Gordon has built a fantastic company for us, and we would like to continue a quality workforce, and we would like to be able to keep what he has built going for a long time to come. And we would appreciate a vote. Thank you.
Thank you very much. The next person signed up to speak is Paul Davis and Sean Dixon. Paul?
I noticed further down the agenda, the family court matter is.
It is on the agenda.
We would probably just wait.
Okay, that's fine. That'll work out really well. Anyone else that would like to speak that's not signed in? Okay, then we'll just move on with our agenda, which is the first item is to order to reopen the estate of Lucinda Page. Mr. Watson?
Doctor, there's an attorney here.
Okay, all right.
Yes, ma'am. I have been retained by several family members that were beneficiaries under the estate. The estate was admitted to probate and appraisement was filed. Letters were sent to the beneficiaries. Several of them or a couple of them responded with letters back asking that an accounting be made before anything else was done with the estate. Somehow the estate fell through the cracks and the probate office closed the estate even though none of the beneficiary waiver forms were signed and an accounting was never filed. Furthermore, the administratrix was allowed to serve without a bond. So we're asking that the commission order that the estate be reopened and she be required to post a bond.
My understanding is that the estate value was $185,000.
Approximately $185,000, a little and change, and she sent checks to some of the family members for approximately $5,000. They wrote back to the probate office and her asking why they didn't get the share that they calculated, and nothing was ever done with it after that.
Okay.
So, and depending on how much money has been paid out to beneficiaries, the appraisement, the bond is based on the value, since it's not a will, it's a testate. So, my recommendation would be to have it reopened, because it probably was closed prematurely, and then a bond should be posted to the value of the present assets that are in her, in the administratrix's hands. So that would be my recommendation.
Okay,
Not a bond of the total amount of the estate before they start paying stuff
Yeah,
out? or-
because it's really what's in her, what she's got now.
Okay.
And she'll
If I may, I asked for, I believe, $150,000, because we understand that we've been able to speak to 6 of the beneficiaries who received $5,000, and we're assuming there were a couple of others, but if it needs to be less, that's fine, but that's what I put in the order, because we know of $30,000 that was paid out.
Okay, so that's, whatever the value is, then that's what it should be.
okay.
So moved.
The motion's been made,
Second.
has been seconded. Is there any further discussion? Hearing none, all those in favor say aye.
Aye.
You can pick a
Opposed,
copy
no.
of the-
Motion carries.
Desk.
Later?
Yeah,
Okay, I'll come tomorrow.
all right.
Thank you.
Thank you.
Next, we have a resolution in the matter of authorizing the signing of the grant contract between the West Virginia Courthouse Facilities Improvement Authority and the Cabell County Commission for the purpose of providing funding for the repair of the perimeter roof line ledge. And this is the grant that we received from the West Virginia Courthouse Facilities. Chad, do you have anything you wanted to say?
No, only that this is the, I guess, the final step in accepting this grant and authorizing you to sign it.
Okay, thank you.
So moved.
Motion's been made,
Second.
has been seconded. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Opposed, no.
Aye.
Motion carries. Next item is a resolution in the matter of the pledging of temporary letters of credit by West Banco Wheeling.
So moved.
Motion's been made,
Second.
it's been seconded. Is there any discussion? Hearing none, all those in favor say aye.
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 Opposed, no. Motion carries. Next item is the matter of pledging of temporary letters of credit by J.P. Morgan Chase Bank.
So moved.
Motion's been made,
Second.
has been seconded. Is there any discussion? Hearing none, all those in favor say aye.
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 Opposed, no. Motion carries. Next, we have a resolution, and it's a state budget revision, number 6.
And this is a state revision to increase the reimbursement, revenue line item 382 to account for increase in the sheriff's budget, for reimbursements for training for Region 2, info citizen security, PEF task force, Governor Highway Safety Patrol, and Parent Education Services.
Okay.
I'll move that.
Second.
Motion's been made, it's been seconded. Is there any discussion? Hearing none, all those in favor say aye.
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 Opposed, no. Motion carries. Next item is a resolution for the employment of Kimberly Dawn Justice as a full-time temporary telecommunicator. Tavon Yonway Felder, full-time temporary telecommunicator.
So moved.
Second.
Motion's been made, it's been seconded. Is there any discussion? Hearing none. All those in favor say aye.
Aye.
Opposed, no. Motion carries. Next would be a letter, a promulgation statement from Gordon Mary, 2 updated annexes of the Cabell County Emergency Operations Plan, Communications and Transportation. Did you have anything you wanted to say? I think it's just an update.
Yes, ma'am, it's something that we're required to do each year. We have to update 2 annexes, and these are the 2 that we picked.
Okay.
So moved.
Second.
Motion's been made, has been seconded. Is there any discussion? Hearing none, all those in favor say aye.
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 Opposed, no. Motion carries. Next, we have a resolution on the reclassification of Shane Black as a full-time EMT, John Hessen as a full-time EMT transport coordinator, Terry Kay as a per diem paramedic, and Zachary Lyons as a per diem EMT. Employment of Alyssa K. Cade, full-time EMT, Shane Clark, full-time EMT, and Shantae Danielle Watson, full-time EMT.
So moved.
Motion's been made
Second.
and has been seconded. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Opposed, no. Motion carries. Next item is letter of intent on family court space. And I think we have someone here today from the Supreme Court to discuss that. Hi, thank you for coming. If you want to stand over there, that'd be great. Anywhere is fine, we're okay.
Up against the wall.
We're very informal. If you want to use the podium, you can pull it out there and use it.
I'm fine.
Okay,
Yeah, my name is Joe Armstrong, and I'm the administrator for the Supreme Court. And we are here today to discuss moving the family court space from the current space here on Fourth Avenue right behind us to the building directly across over here. And the new building owner is requesting a letter of intent so that he can go to the bank to secure money for a bank loan to work to build out the space. So that's what we were here today to ask the commission to consider doing that letter of intent for the new building owner.
okay.
So I'm open for ideas, discussions, questions.
Is it because of the way the law is drafted, code, I guess, that you need the commission involved in it?
Yes.
Okay,
That's okay, that.
short answer on that one, thank you.
When were you contacted about the alternative building?
Back in, I believe it was August, and I've got some other folks here from the court that may know timelines a little bit better, but I believe it was in August. We had some concerns about the current space. There were some advertisements that were put out that indicated in the advertisement that there was a 30-day kick-out clause for the court. And that caused the justices to have a lot of concern about the stability of being able to continue in that courtroom. So what that did is it caused us to start looking at alternatives. We weren't looking at alternatives. We didn't have any intentions to. But when we did, we located a spot that makes more sense to us to be in next door here. It reduces our footprint, makes it a smaller courtroom than what we have currently. It saves us approximately $36,000 a year in rent. And that is a significant amount of money in light of all the things the court's gone through in the last couple of years about spending. We're looking at everything we can do to try to curb spending. And this is something, when we saw this space, and we saw that it reduced our rent, that was one box checked off. It also makes sense to us because we're on 2 floors over here right now. And we wanted we prefer the court to be on 1 floor. So there's 1 security point. So that checked off another box for us, that it made more sense to move into this building. So that's kind of how we got to where we are right now, and are asking for your, participation in us doing this move.
Mr. Armstrong,
Yes, sir.
in the letter of intent, under the proposed transaction paragraph, the last sentence says, the West Virginia Supreme Court will do each of the following: office cleaning, security, cable, and internet.
Yes.
Is that, it's not the position that the county commission is responsible for that?
Correct.
The Supreme Court will see to that?
Yes.
Okay.
I guess my question is, wasn't that anticipated, it being on multiple levels when the court moved from the courthouse over across the street?
I wasn't here, I've only been here about 10 months, so I don't know the history of how it got here.
If I could address that for you, I'm Patricia Keller. I'm one of the family court judges that was involved in looking for that space. we didn't wanna move out of courthouse, but we had to move out because we got a third family court position. So we needed to have a third courtroom and suite, so that's what caused us to start looking. At the time we were looking, there were very few options available for us within the immediacy of the courthouse proper, because it's hard for our attorneys to get from our court to the circuit court or magistrate court all on the same day. So we were able to find that spot. Also, at that particular time, I was the adult drug court judge. And so we had to find a space that would accommodate our drug court as well. So we were able to have that space over there. We didn't want to be on 2 floors, but it's if you're familiar with the building, it's a long, thin building. And so we weren't able to put all of us on 1 floor and also accommodate the adult drug court. Since we've been over there, I no longer have the adult drug court. The Supreme Court has decided they would prefer that handled in circuit court rather than through the family court judge. So I'm not able to do that any longer. So we don't need all that space over there that we currently have. But we weren't looking for 2 floors. 2 floors hasn't been ideal for us because we can't afford to have a security checkpoint on both the 2nd and the 3rd floor now. So everybody comes to the 2nd floor and we have to keep the 3rd floor locked down. And that requires people coming to court on the 3rd floor to usually just take the steps to come up, which can be difficult for a lot of people. We do have elevator access, but it has to be keyed to bring people up, which means our security officer has to leave their station to bring somebody up. And so by being in the new facility on 1 floor, we won't need to transport people among floors, which will be helpful.
I think the part that I don't understand is when this building was selected, the commission was very involved in the selection of the building and looked at numerous buildings trying to decide where to go. We were involved from the beginning until the end. And in this instance, we didn't even know you were looking for a place. We knew absolutely nothing about it till it was just dropped on us. And that one site's the only thing that we're even aware of. Did you look at any other buildings or just land on that one place, or?
I believe they looked at other buildings. Our director of court services and our facilities director were the ones that started looking into this. So they had looked at other facilities. The first letter I had sent here was, and I have a copy of it, I don't know exactly the date, it was in August, where we had expressed our concerns and that we felt like we needed to start looking for possible options. Because we just can't get in a position where we're told that 30 days we have to be out of that building. That's too disruptive.
Can I ask a question? My name is Greg Shoemaker, I'm the IT director for the county. I heard you state that you would be providing internet, which you already provide. And some of the security areas, are your intentions to move the security equipment that exists in that building over here
That
at
is our
Ridget?
intention.
And you still wanna use the phone systems that we provide? Cause a lot of that's gonna take a lot of doing, but it's possible. I just wanna make sure you're aware of.
Yeah, our plan is to take everything and move it over there.
Okay.
That's the plan. The benches, the furniture, everything.
Well, I mean, I just wanted, I'm one guy, it's a lot. I can't recable the whole building, so if you're
No,
covering that and
we can help you with that.
and you're not
We can
taking
do
over
that,
the
yeah.
security, you're just gonna use the existing security. Okay.
Would that be at your cost?
Yes.
Because as I recall, when we moved over here, there was some fluff up about security and grants and various
Yeah,
things,
Yeah. we're
which
gonna
you
move
didn't
that.
cover.
Yeah.
Yeah.
Can I ask you a question about the terms of the lease? Why is it that it's a 30-day notice for either party?
I don't know, and that going forward, we have very few counties in the state. Of the 55 counties, we may have 11 or 12 that are actually third-party lease counties. Cabell is one of them. Our other counties are just direct agreements with the counties, and we don't have a third party involved. I don't know where the 30-day thing came from originally. It's been in there apparently for years and years and years. We would like to, going forward, as we renew leases with other counties, eliminate that 30-day kickout clause, because it gives us a lot of heartburn.
Well, as a realtor, I don't think that should have ever been the case, because for someone to put in millions of dollars of investment into a building and then have to see that diminish on a 30-day, I don't think that that's good practice.
Well, you have to have some kind of an out clause, don't you?
But not, I mean, 30
Yeah, but
days
30
for that
days
type of
is tight.
investment is
That's
not
very tight.
good practice.
You know, what we would be looking at with this, if we do this, I mean, this is something that's gonna take months and months and months. It'll be well into the middle of next year before we're ever gonna be in a position where we move. So there's plenty of notice.
I think we have the owners of the current building here that would like to speak.
We do.
Paul Davis and
Paul Davis,
Shane Dixon.
Sean Dixon.
Sean Dixon.
You know, I think the commission is very, very aware of our situation here. And previous, and I don't mean to call somebody out, but sir, I've been trying for 8 months to contact you, and you will not return my phone calls. And so, I want that on the record, that you're here, and this is the first time that I've met you. We certainly, based on Steve Canterbury, is his name, the previous administrator for your position, helped us, and I'm talking about everybody in this room, as far as commission at the time, helped look for buildings and space for you guys, and you landed in our building. We knew of the 1-year lease, and I think that's state requirement, at least that's what we were told. We did not put the 30-day out in, you guys did. And so, but our bank and Steve and the other justices at the time, including Meacham, said, once the state, we kind of land someplace, look at the building, it looks similar to the courthouse. We modeled it after it kind of looked like a courthouse facility. Said that they very rarely ever move. The bank gambled on it. They loaned us basically $1.2 million to fit out those 2 floors. Now, we are on the, if you guys leave us, we are on the ticket for that. It's going to be to have to come up and find new people to be in that building. It's not fair. You guys made a commitment to us, and you should stay in the building.
Nobody's, like I said, nobody's spoken to us about reducing the square footage. Don't you think if that's the issue, somebody should at least brought it to our attention? Maybe we could did something about that. Nobody, there's been no communication with us. And, like Paul said, you know, if you guys have been in there 3 years, we borrowed really 1.9 million, but 1.2 to those 2 floors. And for some, to just pick up and leave without giving us an opportunity to do something, this is not fair. You know, matter of fact, both those floors were designed by the Supreme Court. We fit them out per the Supreme Court. They had to have so much space for each judge. I mean, it was all based on what you guys said. And so we can't, for the life of us, understand why, you know, just where this is all coming from. I mean,
And I won't put this out here, and it's not fair. I don't know that you've looked at any other buildings, and how I found out about it, there was people in the community, and I'm pretty well known. They said, do you know the judges are standing out in front of Jimmy Wilder's building? And I said, okay, and it's Jimmy Wilder and Phil Nelson. And I said, okay, what are they doing over there? And I started asking around, and that's how I learned that you guys were looking to move out of our space. And then I learned, and I'm telling you, I don't think it's ethical, but Jimmy Wilder and Justice Jenkins are brother-in-laws. So, you know, and Justice Jenkins told me that he had recused himself via a text to me, but still the other justices know about this. How is that fair? I don't know.
It's just not fair.
He is not involved with anything related to this.
Well, it's not fair that we fit that building out, those 2 floors, and did all that work for the Supreme Court with Steve Canterbury, Lisa, they said, you know, and that's what they said. They said, once we get in here, this will be a long-term deal. I mean, why would you go out here and borrow that much money and fit it out for the Supreme Court? I mean, it's just not right. It's not right. And you're talking about all the security. We did all the wiring for the security. We did all the wiring for the telecommunications. We did
The door locks.
all the door locks we provided. I mean, we spent. That's why the cost was so expensive. I mean, we fitted out per the Supreme Court had multiple meetings and all that. I mean, it was designed for the Supreme Court. And all of a sudden, they say, well, we'd rather have one floor. I mean, be on one floor. I mean, it's just not fair.
There's over $2 million in investment in that building over there across the street, and we made those additional investments based on so they would have a nice place to be. And sure, you know, the rest of the building is for lease, but at the time, we were, you know, banking on them being in there for a long time.
I personally think if you guys want to leave, I'd say, okay, but somebody at the Supreme Court ought to be paying for that fit out.
They ought to
Before you know, it's just, if y'all's making a decision to pick up and leave, and besides, all those judges' benches and all that stuff down there, that stuff is nailed down.
It's attached to the building.
I mean, so, you know, you can't, it's not right, it's not right.
Thank you.
Thank you.
If, to sort of sum it up, you're worried that they may kick you out in 30 days. I mean, that's in there. You, the family court and the Supreme Court, see a savings involved of 36,000, give or take. And the layout would be on one floor rather than 2 floors, making more effective use of the space and that sort of thing. Are those the major issues, I guess? I mean, I was just
I think that's accurate.
sitting here thinking.
Well, we have offered, once we realized the 30-day escape clause was an issue for them, just to remove it.
Right.
We would take it out. But no response. There again, we have not been able to have a correspondence with the Supreme Court at all.
Yeah, as I recall, there was a good bit of discussion about the rent per square foot. And I'm just thinking, if I am Mr. Davis and Mr. Dixon, I might rather have part of something than nothing. Negotiations again on rental rates or amount of space or anything else. And I didn't know if that had been
We sent
tried.
an email the 1st of September stating that we're willing to sign, you know, work with them in any way they want, you know, as far as the, even this, the 30-day clause, that wasn't ours. I mean, we, you know,
That was your
we
office.
didn't want that neither. We was told this is the state's
Requirement.
at least requirement, that you couldn't make any modifications to it, so we would, I mean, that wasn't ours. But this email that we'd sent, I'm going to brought a copy of it, that we sent to everybody stating that we are more than willing to sign a long-term lease, or, I'm not sure what else to, you know, guarantee. I mean, we'd like that fidelity also.
Well, the fact of the matter is that there's been no negotiations, there's been no, you know, we learned suddenly that they were looking at.
They're not leaving, I mean, don't you think, I mean, with all that investment we did, we at least deserved a phone call, or a meeting, or something to discuss your concerns. First time we've met you. First time we.
How many other of the 11 third-party leases with other counties do you have to kick out the 30 days? Is it all of them?
All of them right now. And like I said, as we go forward, we're gonna eliminate that with new leases. We don't want that in there.
Did you all have legal counsel when you were making your investment?
They were under the understanding that this was the state law and that we couldn't deviate from it at all. And it was Mr. Cunningham, Ed Cunningham was our legal counsel. Dinsmore and Schultz. And we were told that the state, and I don't know if it's still true, won't allow you to sign a lease for more than a year. And our financial institution says we do this all the time. He goes, because it's the state rules and regulations or statute or code, and we do it all the time. And so we loan money based on, yeah, it's the state, they're probably not gonna leave, and they take the gamble. And so,
We were convinced that the only reason we made that investment was because it would be a long-term buy. The guy previously, I guess, had had good jobs, and people who was working with the Supreme Court said, once we get in here, this is a long-term deal.
and we've built courtrooms inside this building. We are not going to want to leave.
I guess it matters what's on paper, though. That's the
Well, I can't
unfortunate
speak for what happened
situation.
A couple of years ago, I wasn't here, I don't know what they told you or didn't tell you.
There's still 1.2 million that has been borrowed to fit your space out over there. And I think that somehow, if you want to pick up and leave, then, okay, so be it. But somebody needs to be responsible for that 1.2 billion. Because we based it on you guys being there a long time, and the bank did that too.
We had the Supreme Court work with our architect. We hired an architect to deal with the
Lisa.
that had, I mean, as far as the flooring, the ceiling, the space, the bathroom, the requirements, I mean, the whole thing, the whole 2 floors are completely based on the Supreme Court. And we're even, like I said, we're even furnishing the toilet paper. You said on your all's new thing here, you're talking about the cleaning, the security, and.
We're doing all that.
We're doing
That's
all
all
that.
$12,000 a year to clean the building, and you're saying in the new lease, I just heard now, that you're gonna clean the building over there for them. We're supplying the toilet paper and everything.
But why is that change moving forward? And why is that being proposed? I'm just curious.
It's just the agreement that we have, or that we're proposing to have.
Well, we were told that you guys would not sign that because you're normally in courthouses and it's provided by the courthouse. And that we wouldn't have a lease going forward if we didn't do the cleaning of the building.
Yeah, what we're told and promised, I can't speak to that. I wasn't here.
Well, that's in the lease.
Yeah. With the new letter of intent, evidently, you're gonna do more stuff in that building than you're doing in ours. Sounds like.
You can't, nobody could move forward because Nelson and Weiler don't have a letter of intent to take to the bank.
They've asked for that in order to get funding,
Yeah.
in order to get bank loans.
And we are dealing with two local groups, both who have done good things. It's difficult, I think, decisions.
Well,
Now, the big difference is here, we've already borrowed the money here, and we're on the hook for that. They haven't borrowed money yet.
I don't know how the other commissioners feel, because we're not permitted to communicate privately, because two makes a quorum. But I looked at the code that was furnished by you and an email from the Supreme Court, and Chapter 51, Article 2A, Section 20 says that the county commission is required to furnish offices for the family court judges. Each county commission of this state has a duty to provide premises for the family court which are adequate for the conduct of the deputies required of the court under the provisions of this article, and which conform to standards established by the rules, which I think the retrofit was established by the rules promulgated by the Supreme Court of Appeals. The administrative office of the Supreme Court of Appeals shall pay to the county commission a reasonable amount for rent for the premises furnished by the county commission to the family court and his or her staff pursuant to the provisions of this section. And so what I would suggest is that it's the duty, the responsibility of the county commission to provide that space, whether it be in a courthouse or whether it be in a third-party situation, or if the county owns a judicial annex. So, as I see it, it's our responsibility, and I think that there has been a big lack of communication on all parties. All parties. You know, whether it be the current investors, the new investors, the court, the commissioners. And I would suggest, I'm not prepared myself to vote on this today. I did, in full disclosure, receive one phone call from one of the family court judges, which I very much appreciated a few months ago, just to say that they were looking. But that's been the extent of the communication. And so since it's our duty as commissioners, charged by the taxpayers to make the appropriate decisions, I would suggest that we lay this over. I would like to visit the building. I would like to talk to all stakeholders, and I think that is the fair thing to do.
Sure. What's the date of the first letter that Because I don't want you to think we didn't communicate back in, I think it was August. August 26th. Back in August. that you-
Who did that letter go to?
Us,
Ms. Thompson.
and I got it to you all that
Yeah.
night.
But we were not involved in the process after that. That was all we knew. And it was just such a deviation from what had happened in the past, because we were very much involved before, looking at buildings and participating in the whole process. So we knew what was going on.
I think it's very fair to go over and look at everything. Fine.
Are you making a motion to table?
I am.
We have a motion on the floor to table this
Second.
issue. It has been seconded. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Opposed, no. The motion carries and the item will be tabled. Thank you.
Thank you.
Next item on the agenda is a resolution in the matter of addressing holiday hours for Christmas 2019, New Year's 2019, 2020, and other 2020 holiday hours for the Cabell County Commission of Cabell County, West Virginia. And we just learned yesterday that the governor's given us Christmas Eve off.
Right.
So,
Typically in the past, he's had to do it like the day before.
yeah, that's
So
right.
this was in trying to predict what he was going to do for those holidays. But, this would just, if he proclaims additional hours, then you all will, adhere to those same things.
Okay.
So
And the reason
we'd
I
already
included-
set these, hadn't we? And this is,
Well, you'd set the regular holiday
Right.
hours, but this is just if the governor declares additional.
As he
which
usually does.
He usually does, and it's usually like the day
Right.
before, and you all aren't meeting. So this was to try to anticipate if he did that.
so move.
Motion's been made.
Second.
It's been seconded. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Opposed, no. Motion carries. That brings us down to executive session. We need to talk to our attorneys about a litigation update. So we need a motion to go into executive session.
I make that motion.
The motion's been made to go into executive session with our
Second.
attorneys.
Yep.
Has been seconded. All those in favor say aye.
Aye.
The county commission is back in session after an executive session where there was no action taken, but we do have some action we would like to take in this open meeting. So at this time,
I have a motion I would like to make. Rather lengthy, and we'll have a copy for you. You already have one. I move we authorize council to file motion to sever and seek remand against Cardinal Health, McKesson, and Amerisource Bergen. The commission will reserve all causes of action and damages against the remaining defendants. Move that the,
you want to do them all at once? We probably ought to
want
do
to do
them
them all at
separately.
once?
We probably should do them separately. Yeah.
What's that?
The attorney says we should do them separately. Okay.
So-
Do I hear a second to the motion?
I second that.
The motion's been made, it's been seconded, is there any discussion? Hearing none, all those in favor say aye.
Aye.
Aye, opposed no, motion carries.
I move that the Cabell County Commission authorize council to dismiss all claims in the complaint except for public nuisance, including abatement, civil conspiracy, and punitive damages against Cardinal Health, McKesson, and Amerisource Bergen.
Second that motion.
The motion's been made, it's been seconded, is there any discussion? Hearing none, all those in favor say aye.
Aye.
Opposed no, motion carries.
Move for waiver of all past and future economic losses incurred by the Cabell County Commission to pursue solely abatement of the public nuisance against Cardinal Health, McKesson, and Amerisource Bergen.
Second that motion.
Motion's been made, it's been seconded, is there any discussion on the motion? Hearing none, all those in favor say aye.
Aye.
Aye, opposed no, motion carries.
I move to approve and verify the answers to interrogatories and responses to requests for production of documents and authorize Beth Thompson to sign the verification.
Motion's been made,
Second that.
it's been seconded, is there any discussion? Hearing none, all those in favor say aye.
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 Opposed no, motion carries.
Motion to approve Commissioner Kelly Sabanya and Beth Thompson, County Administrator, to testify for the Cabell County Commission and speak on its behalf.
Second the motion.
The motion's been made, it's been seconded. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Aye, opposed, no. Motion carries. Moving on, we need to place on record minutes to be recorded for the Culloden PSD special meeting, October 2nd, 2019, Culloden PSD regular meeting, October 23rd, 2019, Pea Ridge Public Service District regular meeting, October 14th, 2019, Salt Rock PSD regular meeting, October 15th, 2019, Cabell Huntington Health Department regular meeting, October 23rd, 2019. Documents to be recorded include Cabell Huntington Board of Health report, November 2019, Pea Ridge PSD General Ledger Balance Sheet and Income Sheet Period 4, year ending 2020. Pea Ridge PSD Field Report and Managers Report, September 2019.
So moved.
Second that.
Motion's been made, it's been seconded. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Opposed, no. Motion carries. Do we have any commissioners' representation reports?
Just like to say happy birthday to Beth and Marie and Jim.
Everybody's having birthdays.
So happy birthday, so happy birthday. Should we sing?
Yes.
And you will lead us?
Yes.
Okay.
Happy birthday to you. Happy birthday to you. Happy birthday, dear everybody. Happy birthday to you.
We're all gonna be drug tested.
Thank you.
Thank you all. Thank you.
Is there anything for the good and welfare of Cabell County? Hearing none, after we sign the necessary documentation, the meeting will be adjourned. Thank you all for coming.